Good afternoon and welcome to How to Navigate the Maze, HR Compliance Challenges in 2024. In a moment, I'll introduce to you the presenters, but first feel free to use the chat functionality at the bottom of your screen to ask any questions you have during today's presentation. We'll get to as many questions as possible by the end of this presentation, and if we don't get to your question, we'll be sure to follow up with you in the next day. My name's Raleigh Merrill. Welcome to this presentation by GTM Payroll and HR. You're going to receive an email later today that will link you to watch a recording of this presentation today, as well as a version through PDF of this presentation. Our presenters today are Martin Patrick and Jennifer Berry. Nicole Camuti is under the weather and cannot join us today, so we appreciate Jennifer stepping up to share her knowledge and expertise for today's webinar. Martin Patrick brings extensive human resources experience to the GTM team as a strategic member of corporate senior management in for-profit and not-for-profit, union and non-union environments. As a consultant, he's worked on assignments at a not-for-profit global research institute, an engineering R&D startup, a multi-state retail employer, a physician practice, a manufacturing service provider, a not-for-profit national accreditation company, and various other businesses that have been successful. His project work includes developing compensation structures, human resource audits, employee management and training, employee handbooks, job descriptions, employee classifications, and employee investigations. Jennifer Berry brings more than 20 years of human resources experience to our GTM team, including mergers and acquisitions, HR project management, HR and benefits compliance consulting, third-party compliance, and more. She has led HR and process audits, ERISA audits, employee handbook projects, benefits administration platform deployment, and she's deployed and delivered training on HR benefits compliance. Jennifer also has consulted with clients on all areas of HR, including leave management, talent acquisition and termination, benefits enrollment, compliance, and ACA, HIPAA, COBRA, and state and federal compliance notices. Okay, let's start navigating that HR compliance maze. And to do that, well, we're going to turn things over to our presenters, starting with Martin Patrick.
Hi, Raleigh. This is Jen, and I believe that Martin is having audio issues currently. So I will start the presentation, and Martin can feel free to jump on as his computer allows. So we're going to start off with minimum wage rates on the rise. They've been consistently going up over the last number of years, probably the last 10 years, and New York being as employee-friendly as it is, will continue that trend over the years. They're typically seeing annual increases. Those increases will come across somewhere in the late fall usually, and will go into effect typically on December 31st. So it's one of those things that you should keep a watch for as you enter into the end of the year and the new year. Sometimes there are local rates too, so keep your eye not only on the state changes, but also on local rates. California is notorious for having a state rate, a local county rate, and a city rate. So if you do any business in California, especially, we definitely suggest that you keep your eye on those minimum wage rates and the variations within the state. But we're seeing trends in some of the employee-friendly states, such as New York and California, in the $16 wage rate, while others remain lower, closer to the federal minimum wage rate. In addition to the regular minimum wage, there are also some minimum salary requirements for exempt status. Generally, exempt employees must satisfy a number of tests in order to be considered exempt. And what exempt means is that they are exempt from the overtime rules, meaning they can work as many hours as they need to get their job done, and you are not required to track their hours and pay for overtime. So exempt employees must satisfy a duties test, meaning their job would be considered exempt, They must also be paid by salary and have a certain salary threshold, which is what we're going to talk about here. The executive administrative and professional roles are those that we're talking about right now. And those are referred to usually as white collar exemptions. So that's what this is going to focus on. The current federal exempt status salary threshold for executive, administrative, and professionals is currently at $684 per week. That's about $35,500 a year. The U.S. Department of Labor is set to issue its final rule amending salary level requirements for white-collar exemptions in April. So keep your eye out for some new minimum salary rates coming through for the federal exemption. This would revise salary thresholds applicable to executive, administrative, and professional exemptions, as well as those who are considered highly compensated. Employers in New York State have to be careful, though, as New York State not only has a higher exempt salary rate, but it also differentiates among who their exempt employees are. They have one category for exempt executive and administrative employees and another category for exempt professional employees. The new New York exempt salary threshold for executive and administrative employees has been increased already at the end of December. It's currently $1,200 in New York City, and that includes the counties in Long Island as well as counties up to Westchester. And it's at $1,124.20 for the rest of the upstate area. These minimum exempt salary amounts are scheduled to increase over the next 3 years, so keep your eye out again as you're heading into your year end or your new year planning. New York State does not require professional employees to meet a minimum exempt salary amount, so they do not have to meet those, but they do have to meet the duties test that I mentioned earlier. They do, however, have to meet the federal minimum exempt salary level, so that may affect some of your employees, especially if they release a higher exempt salary level at the federal level coming up in April. Please note this exempt salary increase that has occurred and any that are coming down the pike should not be confused with a separate increased salary for purposes of pay frequency laws. Pay frequency laws we will cover in a couple of slides, but there's a separate exempt salary threshold for that, which is $1,300, and that's effective as of March 13. So as you can see, there's a trend amongst our compliance slides here that a lot of them have to do with pay. And it's because, especially employers in New York, they're actively looking to audit employers as it relates to pay. And that can be making sure people are making minimum pay. That can be making sure that people are classified correctly, so they are being paid as exempt or non-exempt employees. And it also refers to call-in pay for the state of New York. If a non-exempt employee is required or permitted to report to work, even if they're not assigned actual work, they may be entitled to call-in pay. This doesn't mean that an employee who works less than 4 hours will necessarily receive additional pay beyond their hours worked. If total pay for the week exceeds minimum wage for the hours actually worked, plus the extra hours attributable to the call-in pay provision, then no additional pay is required by the wage order. When the rule does apply, restaurant or hotel workers typically are entitled to a minimum of 3 hours pay at the applicable minimum rate, and employees in other private workplaces are entitled to 4 hours minimum pay at the applicable minimum rate. This rule may not apply to every industry or if employees are covered by a collective bargaining agreement. So make sure you know if there are any outstanding agreements that may affect this rule. Bottom line, total compensation would need to be evaluated for the week to determine full amount of call-in pay owed to a non-exempt employee. And again, this does only apply to non-exempt employees and not what we just discussed on the previous slide. Pay frequency is becoming a very common compliance area and something that many employers get wrong. Oftentimes, they are paying people on the same pay frequency because it just makes sense from a logistical standpoint. But we want you to know that New York State requires certain types of workers to be paid on certain frequencies, and they're not all the same. So New York State requires employees with certain job duties to be paid at a minimum frequency. Please note that each state has different provisions for pay and paid frequency. So if you're operating in multiple states, we always recommend that you take a look at what those states are requiring, both regarding minimum pay as well as pay frequency. New York law requires clerical, administrative, and non-manual workers to be paid no less than semi-monthly. Most employers pay these employees via 26 or 24 pay periods across the year, either bi-weekly or semi-monthly. But please be careful. If you have any manual workers, they must be paid weekly, and they can't be paid any more than 7 calendar days from the end of the week in which the pay was earned. This is often overlooked by employers, even those who are up on all of their compliance matters. And this happens when people choose just to pay on the same pay cycle for all employees. So the biggest question about this is who qualifies as a manual worker for purposes of pay frequency? This is a very, very underdefined term for something so important in the state of New York. However, New York labor law defines a manual worker as a mechanic, working man, or laborer. It has been the longstanding interpretation of this that it applies to any worker who spends more than 25% of their working time engaged in any type of physical labor. Physical labor is quite broad, and it includes any physical tasks performed by employees. Examples of manual laborers would be a construction worker, a maintenance professional, an auto mechanic, etc. Please note that federal, state, and local government employers are not covered by this law. Also, employers may not ask employees to agree with a different pay frequency or a different pay period than that which is required by law. So you cannot go to your employees and have them sign off on being paid less frequently than the law requires. You also have to, as a side note, always make sure that you're obtaining written consent from employees if you're paying them via direct deposit. That's just a little side note. Many employers are paying most of their employees by direct deposit these days, but they don't always have the correct records to show that their employees authorize that type of payment. And again, as I mentioned earlier when discussing exempt employees, pay frequency laws in New York do not apply to bona fide executive, administrative, or professional employees who earn in excess of the new minimum wage for purposes of pay frequency, which is $1,300 a week, which went into effect on March 13th. I see Martin is on. Martin, are you unmuted or are you available?
I am here. Thank you.
Oh, excellent.
I apologize for being late. I had a little technical difficulty here, but I'm going to go on and start on the next slide and welcome everybody to our webinar today. Again, for this slide, this is a new law that came out in New York State last year, and it's there's a part of the law that basically has been in effect for a while for what they call criminal larceny charges under the law, and they added wage theft to it. So if an employee is not being paid correctly by an employer, there can be a charge of criminal larceny against the employer. So it is very important that employers are paying the wages correctly.
So in addition to that, in addition to making sure we're paying our employees correctly, it's very important that we classify our workers as either employees or independent contractors. Misclassifications of independent contractors is becoming much more frequent. It's really vital that you understand the distinction between independent contractors and employees, because this will affect you and your business and could create tremendous liabilities for misclassification. You may genuinely believe that you've hired people to perform services for you as independent contractors, but you may then later discover that by law they are considered employees and that you are liable for unemployment insurance contributions and interest, and oftentimes penalties. Whether the relationship is one of employer-employee will depend on several factors. These include how much supervision, direction, and control you have over the services. New York state law in this area, much of which comes from courts and case law, has determined that no single factor or group of factors conclusively define an employer-employee relationship. Rather, all factors are reviewed to determine the degree of supervision, direction, and control exercised over the services. Generally, an employer controls what will be done, the manner, the means, and the results. Conversely, independent contractors are free from supervision, direction, and control in the performance of their duties. They also are typically in business for themselves, offering their services to the general public. So they typically are not working for you alone and are offering the same types of services to other employers and businesses. Earlier this year, the Wage and Hour Division at the Department of Labor issued a final rule, which became effective this month, as to how you would analyze an employee versus independent contractor under the Fair Labor Standards Act, or FLSA. The new rule provides much more consistent guidance and greater clarity. It's based on the economic realities test, which has been used for years, but just the clarity is more distinct in this ruling. Federal courts will take this 6-factor test into consideration. And here are the factors. Does the work's managerial skill affect their opportunity for profit or loss? How does the worker's investment compare to the employer's investment? Is the relationship between the worker and the employer permanent or indefinite? What's the nature and the degree of control over the worker? Is the work performed by the worker an integral part of the employer's business? And does the work require special skill or initiative? A totality of the circumstances is reviewed here, not just one single factor, and the ultimate inquiry is whether, as a matter of economic reality, a worker is economically dependent on the employer for work. If so, they are an employee. Or are they in business for themselves and would be considered an independent contractor? This interpretation is on the federal level and does not take into account that New York guidance we discussed on the previous slide. So I think a realistic approach is to take into account all of these factors and really look at the control that you have over the worker and determine whether they are an employee or an independent contractor.
Okay, the next slide is we're going to talk about child labor laws. And you may have seen some of this in the news recently, especially in some other states other than New York. But you should know New York State has one of the most strictest laws with regard to child labor in the country. So again, one of the things you need to know is the restrictions. And again, if anyone is under age 18, there are restrictions specifically during school hours when individuals can work, when they can't work, and the number of hours they can work. And again, if they're age 14 and 15, there's really a limited work hours every day and every week, and also on a schedule. There should be a schedule of hours that dictates when, by the employer, when the individuals are working. So one of the considerations is, as always, and it always has been, is the people under 18 should have working papers. They should be presenting working papers to their employer that can easily be obtained, and the employer is supposed to retain these working papers through the duration of the employment of the individuals. And again, ideally, you want under the proper provisions for position, you want to have a schedule for the employee. You want to have a written schedule of the hours that they're working.
Each employment record has both federal and state requirements for retention and location and storage. HR record keeping is very important. In addition to all of your pay records, which would include some of the classifications and pay rates that we've discussed on earlier slides, there really is an important way to keep records related to employees. And we often recommend an HR audit in order to determine if you have your records kept correctly. Again, there are requirements for both retention, meaning how long you need to keep them, as well as how they're stored or how they're located. In New York State, there are a few requirements. So where do you keep certain records? Well, there are usually 4 types of employment records. There's the classic personnel file, there's an employee confidential medical files, there's a Form I-9 file, and an employer confidential file. You can see on the slide which records fall into each category. All documents must be separated based on category into each of the separate files. For example, Form I-9 must be kept separate from the personnel files, which include the wage theft form and payroll records. And confidential employee medical files should not be kept with the general personnel file. Confidential organizational documents are typically kept in a separate file, only accessible by limited people. All employee records should be limited in access. Employers are also able to provide policies about how and whether employees will have access to their own employment files, both during and after employment. So in addition to how we have to keep these records, how long must we retain these records? And a lot of this is based on New York law. Again, I recommend if you're operating in multiple states that you take a look at those local record keeping requirements. But in New York, general personnel records, such as job applications, transfers, resumes, job postings, employment tests, requests for reasonable accommodations, those would all need, and in addition to the I-9 and employee benefit plan information, that all must be retained for at least a year. And please note that with an I-9, it can be destroyed after 1 year after termination, but not less than 3 years from date of hire. So if you have a very short-term employee, please make sure you're looking at that qualification of the 1 year versus the 3 years. Wage payment records and wage rate tables, earning records, that all must be kept for a minimum of 2 years. Payroll records showing an employee's name, address, rate of pay, compensation earned each week must be kept for 3 years. However, and to make things more confusing, true and accurate payroll record, which is a term of art used by New York State, for each week worked and the hours worked, which include the gross wages, show the deductions, allowances, etc. It's typically what reflects what's on a pay stub. That must be kept for 6 years. And I know that's very confusing having so many differences regarding number of years you should keep pay records. I typically tell my clients to keep them all for 6 years because to differentiate between the different classifications is sometimes difficult, but those are very important to keep track of and make sure that you're keeping for the required number of years. If you need more information on specific retention requirements for certain records, absolutely contact GTM's HR consultants for more detail. We have lots of resources on that and can advise you. And again, please note that each state will have different requirements. And also the federal law also requires some requirements that are actually longer than New York State. So it's often important to keep both of those in mind.
Okay. The other part of our webinar today is to talk about HR audits. And this is an important thing that I can't stress enough that all companies should be doing at some point, especially as the company's growing. Okay, next. There we go. So what is an HR audit? It's basically an objective examination of your policies and procedures. So it is looking at it's looking at the everything that's happening in the HR and the world, and it's done on an objective manner. What you want to do is you want to do it internally. You have somebody coming in and examining all the records that are related to HR. The scope of it really is really determined by the budget you have as a company and the time frame that can be allotted. You can do a shorter version of an audit, or you can do a longer version. A lot depends on the scope that the company is comfortable with. But there are some basic things that should be done in every audit, and it starts with identifying issues like compliance issues. So you're looking at are you compliant with the pay issue, laws that are required, employment laws that are required. You're looking at what we've talked about in the first part of this presentation, all the things that are related to HR, and you're reviewing those. You're reviewing the best practices. You're looking at are all the actions that you're doing as a company compliant with state and federal and in some states local laws. Yeah, that you're doing this. You're trying to be proactive when you're doing this. You're looking at ways of ensuring that when you identify concerns when you're doing the audit, that you present remedies to get these corrected. So you want to be ahead of the game. So if someone's coming in to do an audit, it should be somebody that understands all the ramifications on a compliance level, reviewing them and making sure that you as a company are what your exposure is and what needs to be done to remedy the situation. We have a team of consultants who do audits quite frequently. We do them for all different types of businesses, and we're looking at these practices. And typically what happens is that when we're doing something like this, we're examining everything, and then we present a report with remedies that can, again, make you safer than you are now. And one of the example we would do, for example, we come in and do an I-9 audit. That's a federal document that you have for all of your employees. It's a record of employment. And we will look at any deficiencies that you have and measures you can do to be self-correct yourselves and get it done. And so you're compliant right away. There are different aspects to an audit, but in the end, it's a compliance-related instrument. So it's making you as a company compliant with all the federal and state laws.
So as Martin said, our GTM team of HR consultants are doing HR audits for our clients. It is considered a fact-finding mission. So the first thing we would do when we come in is meet with you and discuss a little bit about your business, the number of employees you have, and the type of records that you're keeping. Information is gathered from the internal HR point of contact typically. So your lead HR person would typically be working with our consultants. And then the consultants would ask for a list of people who they could also contact who may have information regarding your insurance, for example, or retirement plans. All of this falls under the HR umbrella, so it certainly would be part of HR audit. We would also ask if we could access some of your payroll files and see how you're using those and also how you are retaining those. So oftentimes the HR audit will consist of mainly using the HR person on site as the main contact and then utilizing them to access their various consultants and other people working with them under the HR umbrella. On-site records are physically reviewed. So that list a couple slides ago would be reviewed. I personally go through individual employee records and make sure that all of the required documents are in there. I typically would either denote in the report or remove myself documents that do not belong in there. But ultimately trying to get the overall record and employment file compliant. Issues overall are identified and presented in a report. And oftentimes the HR consultant themselves could help and assist through working through some of those compliance issues that they identify through analyzing your records and your business. So it really is a team approach, but we as HR consultants certainly have a lot to offer as it relates to remedying some of those problems. The time for an HR audit really varies on the type of business you have, the business demands, and how much attention your internal HR person can give to the HR consultant. Also, how large your business is would affect as well, because that would also go to how many records and different things you're having to review. Findings can be remedied, like I said, with the assistance of our HR consultant team, and we do have expertise from all areas of HR on our team, so we're very happy to help in that area once we have the results from an audit.
All right. Thank you, Jennifer and Martin, for all this great information. And now, before we get to your questions, just a quick word about GTM Payroll and HR. We've been in business for more than 30 years, and today we offer a leading-edge human capital management solution through iSolved, as well as expert human resources consulting services from experienced HR professionals like Martin and Jennifer, as well as customizable insurance solutions and employee benefits. By combining payroll, HCM, HR outsourcing, insurance, and benefits through GTM, you'll reduce costs, increase efficiencies and productivity, accelerate key business decisions, boost employee performance and engagement, and best of all, you'll be the HR hero with your organization. Our HCM solution integrates business functions into a single source that automates procedures from hiring through retiring, increasing data accuracy, simplifying your operations, and escalating your productivity. On the consulting side, our HR professionals understand how to develop HR strategies that align with your business goals, bringing value to your company by finding ways to lower costs and streamline processes. The GTM insurance team offers business insurance and employee benefits that can be integrated with your HCM platform to streamline processes even further. For example, open enrollment becomes much easier, saving all that time by eliminating manual tasks. We offer some great rates with no administration fees from the local carriers you know and trust as well. And all GTM payroll and HR clients are assigned a dedicated customer service manager. That means someone who gets to know you and your business. Now on to your questions. We had a few questions that came in through our sign-up process, so we'll get to those first. Here's the first one. I need a better understanding of the threshold for exempt versus non-exempt employees and tracking hourly pay versus salary. Jen, can you help us with that one?
Sure. As we mentioned earlier, it is important to make sure that you're classifying employees appropriately based on their pay and their duties. So I encourage you to take a look at whether your employees have duties that are considered exempt. And if you need information about that, I'm happy to share it. Whether they are paid by salary, and also whether they make that exempt salary minimum amount that we talked about earlier. It is also important for tracking purposes, as you will need to have accurate records in order to calculate overtime for those who are eligible. So anyone who does not meet those exempt requirements would be considered non-exempt and are eligible for overtime. For exempt employees, there are many employers that still have them track their time in and out every day. That may be for billing purposes or for other reasons, but for purposes of non-exempt employees, you absolutely have to track their hours of when they're working and when they are assigned to work duties. Because you absolutely need to know the exact number of hours they're working. If they are working over 40 in a given work week, they are eligible for overtime. And that's where we get into some trickiness as it relates to making sure you're paying appropriately. You can use both a human capital management system or a payroll platform to manage hours for your hourly employees. You absolutely can reach out to our GTM sales team if you're interested in hearing about how we can assist in managing employee hours, overtime, and pay. And like we said earlier, our HR consultants are happy to help in identifying whether employees are exempt or not exempt, or even whether they're classified in other ways, whether it's an employer or independent contractor. Thank you, Raleigh.
Thank you, Jen. All right, here's another question. This one's for Martin. This is another one that came through in the registration process. In New York State, if you provide 40 hours of sick time, does it count as the COVID leave, or is the 40 hours of COVID leave in addition to the 40 hours of sick time?
Good question, Molly, and a common question we received from a lot of different employers. The COVID sick pay is definitely separate from the paid sick leave of New York State. Right now, depending on the size of the employer, will determine if you're paying how many sick hours at a minimum, either 40 hours or 56. And then the COVID sick pay is separate pay. Right now, there is a bill in the legislature to sunset COVID sick pay in New York State at the end of July. I have not heard it's passed yet, but it's anticipated that it will happen. But as of now, there is still COVID sick pay, and it is separate from New York State sick paid. sick pay. And we do recommend that you keep these separately, tracked separately in your payroll system.
All right, Martin. Another question for you. If a company is exempt from filing the annual 300A because of their business function, do they still need to keep OSHA records?
And again, just some background on this question. The minimum number of employees is 10. If you have less than 10 employees, you don't have to keep the OSHA log and records. But my recommendation is that for a couple purposes. One is that you are still keeping track of potential employee injuries. So there are requirements under OSHA if a person has an injury, certainly a tragedy like a death or a loss of a limb or eye, that has to be reported to OSHA immediately, no matter what size of company you have. So keeping the logs of injuries is, even if you don't keep it on the OSHA 300 log, is a good idea because also it's tied into your workers' compensation. So my recommendation is to keep those records and use them for whatever purpose, and even safety purposes. If you're having injuries, you're a small employer, you want to try to address those injuries, because you still have an obligation as an employer to have a safe workplace.
And Martin, just if I can jump in here for a second, I find that those keeping those records are important too, especially if you have a large number of workers' comp cases to analyze trends and injuries. So we've used those previously to analyze the types of trends and then provide training or other resources to employees to try to limit those, which will obviously end up reducing your workers' comp obligations.
All right, Martin and Jen, if you're up for it, we have a few more questions that have come our way through the chat. And I'm going to throw this one to you, Jen, because it kind of dovetails off of something that you answered a little bit earlier. But Scott says, I'm an HR rep at a secondary school. Can I get a better explanation of non-exempt versus exempt for faculty at school?
So in New York State, most faculty are considered, they fall within the professional classification. So as a result, they are considered exempt. And New York is interesting that way. And this is what I discussed on the slide earlier, in that they separate executive and administratives from professionals. Professionals in New York State do not have to make the minimum exempt salary amount. So instead, you're looking at the duties and making sure they have education that has led to them becoming faculty and teachers. And that would also apply to counselors and some of those other specialized areas in the school environment.
Thank you. All right, here's one for you, Martin. And this is related to somebody who may have the iSolve software through GTM. Maybe they're using the online onboarding for their employees. And Karen asks, if our employees are onboarded through iSolve, do we need to have hard copies of the I-9?
That's a good question. I believe that answer is yes. And what will happen is you should have the I-9s kept in a separate location. I think that's part of the law. So if you're having some employees complete the I-9 through iSolve, you still have to keep them in a separate location. And I have employers, clients who definitely will print them out and keep them in a separate folder.
To actually print them out, even though they have it on a server somewhere and electronic file form, to print them out and save them somewhere.
If there were ever an audit done, if the government came in, they would want to see hard copies. So again, if you don't do that, you just keep them electronic, you're going to end up probably printing them out for government inspectors.
Okay, here's a jump ball question for the two of you. Whoever jumps in on this is another one about record keeping. Lori asks, how long do I need to keep paper records, paper copies of performance evaluations of active employees if you moved to a digital system last year?
So as it relates to some of the general employee records, which I would consider that to be part of, those can entirely electronic. They don't have to have a backup a paper copy like Martin mentioned about I-9s. No one is going to come in and audit and say, I need to see a paper file that has them held separately. So I would consider those part of the general personnel file. Them either electronically or in paper form. Some people still are transitioning and have a version of each. But the important thing is that it's filed in the correct file, which would be the main personnel file. And typically in New York, you would keep those for 2 years.
Awesome. And of course, with GTM and iSolve, we'll never purge that information. So we'll always have it available to you in the system. All right. We still have a few more moments. If we have any more questions, please feel free to pose one in the chat below. Just a couple more minutes. So let's see if we get another question or two. Giving a little extra time because I know how slowly I key in my questions in the chat. But it looks like that's what we have. Thank you all very much for joining us today. Thank you to Martin and to Jennifer for sharing their expertise. And to our attendees, if you have additional questions, something occurs to you later, you want to dive deeper into all of this, feel free to reach out to Martin or Jen. Their contact information's right there on the screen. And thank you for joining GTM Payroll and HR. Be sure to look for that email with the link to the video recording and PDF versions of today's presentation. Have a great day and thank you.